Something almost unheard of in modern American legal history is unfolding right now. And it has nothing to do with rumors, leaks, or political theater. A former First Lady of the United States is now facing the real possibility of being required to give sworn testimony in federal court about her residency, her marriage arrangements, her tax and financial records, and her past associations, all because a single legal strategy backfired. What began as a threat to silence a journalist has turned into a court-driven discovery process that can compel documents, depositions, and legally binding answers. Not through an investigation, not through an indictment, but through a routine procedural move that triggered mandatory federal review. This is a case about jurisdiction, not headlines. About procedure, not politics. About discovery, not speculation. And once discovery begins, control over the narrative is no longer in anyone's hands. Stay with this, because what is now moving forward in court could permanently place deeply private records into the public legal record, not by choice, but by rule. This situation was not created by an exposé, a whistleblower, or a new criminal filing. It was created by a legal decision made by Melania Trump and her own legal team. There was no ambush and no hidden maneuver. A routine defamation dispute was voluntarily redirected into a federal forum where the rules are far more rigid, and once that step was taken, the consequences could not be paused, negotiated away, or softened through public messaging. While public attention remains fixed on political headlines, a quiet and highly structured legal process is now underway. One governed by sworn testimony, document production, and strict penalties for false statements. Status, visibility, and proximity to power offer no procedural exemption once this process begins. This is not a scandal narrative. It is a step-by-step example of how an aggressive legal threat unexpectedly opened the door to mandatory discovery, and how an effort to deter reporting instead created a pathway for court-authorized inquiry into residency, financial documentation, and personal records. The central point is not politics, it is accountability through procedure. To understand why this situation is so consequential, the names and the public profiles have to be set aside. The driving force here is not what a journalist published. It is a strategic legal choice that transformed a manageable defamation disagreement into a complex federal jurisdiction dispute. In legal practice, this is often described as an unforced error. No court required this move. No opposing lawyer compelled it. It was a voluntary decision to shift an active case into a jurisdiction where participation is comprehensive and compulsory. At its core, the dispute is not about reputation. It is about whether federal jurisdiction properly exists. And in the American legal system, procedure frequently carries more weight than public argument. A party can believe its position is strong and still be required to answer questions it never intended to face. Once federal rules are invoked, participation is not selective, it is complete. This is why the moment matters. What is now unfolding is not celebrity litigation spiraling into spectacle. It is the legal system responding exactly as designed when litigation strategy itself becomes the trigger. Discretion and leverage are replaced with testimony, documentation, and permanent record-keeping. The chain of events began with a formal legal demand sent to journalist Michael Wolff, warning of an extremely large defamation claim and requesting retraction and public apology over reporting concerning Melania Trump's alleged associations, including references involving Jeffrey Epstein. The letter was framed as an escalation, not as an invitation to resolve a dispute quietly. Instead of waiting to be sued, Wolff filed first. That single move shifted the balance. A private warning became a public court filing. The dispute moved into an open judicial forum, and the ability to manage exposure narrowed sharply. Wolff's filing addressed the challenged statements individually and argued that they were protected opinion, contextual reporting, or supported by existing public material. Most importantly, the filing characterized the threatened litigation itself as an attempt to discourage speech, a strategic lawsuit against public participation. Once that issue was raised in court, the focus widened from the statements alone to the legal tactics behind the threat. At that point, Melania Trump's legal team still had procedural options available in New York State Court, where discovery practices are more limited and familiar. Instead, they sought to move the case into federal court. To do that, they relied on diversity jurisdiction. That choice made residency the decisive issue. And the moment residency was placed in dispute, federal procedure required the court to allow jurisdictional discovery so that it could determine whether it had authority to hear the case at all. This is not optional discovery. It is not discretionary discovery. It is required. From that point forward, the case stopped being theoretical. Jurisdictional discovery is designed to answer one narrow question, where a party is legally domiciled. But answering that question necessarily draws on patterns of daily life. It may involve sworn testimony, written interrogatories, subpoenas for documents, property records, tax filings, travel information, and financial materials that reflect how and where a person actually lives. Every answer must be given under oath. Every document produced becomes part of the evidentiary record. This process does not exist to examine public image. It exists to resolve legal authority. And once it begins, it cannot be undone simply because the inquiry becomes uncomfortable. If the residency claim ultimately fails, the discovery already completed does not disappear. Statements made under oath remain part of the record. Documents already produced remain accessible to the court, and in many circumstances, to the public. This is the point of no reversal. One area of potential relevance involves educational enrollment records connected to Melania Trump's son, Barron, who was enrolled at a university in New York. Universities routinely require residency representations for tuition and administrative purposes. If different residency positions were taken in different contexts, those records may become relevant to resolving the federal jurisdiction dispute. This is not about personal life coverage. It is about consistency across official representations. Federal courts cannot avoid this inquiry. Jurisdiction cannot be assumed. It must be proven. Once a good faith challenge is raised, the court is obligated to allow discovery sufficient to resolve it, regardless of who appointed the judge or how sensitive the information may be. Even if the underlying defamation claims are ultimately dismissed, the discovery that occurs to determine jurisdiction remains part of the case history. That is the practical reality of this legal pathway. At this stage, the remaining options are limited. A return to state court would not erase what has already been produced. Settlement now carries little leverage, particularly for a party that has already invited judicial review of its own jurisdictional claims. Attempts to narrow discovery too aggressively risk further procedural conflict rather than resolution. The likely outcome is straightforward under federal practice. Depositions proceed, records are exchanged, and sworn answers become fixed. From this point forward, the case is no longer shaped by public messaging. It is shaped by the record. This is not a personal drama. It is an institutional moment. It demonstrates how legal systems designed to protect open expression can also restrain litigation strategies intended to discourage it. Threats alone do not resolve disputes in court. Rules do. And when those rules are triggered, they apply equally, regardless of wealth, profile, or political association. What is now underway is not spectacle. It is process. Discovery has been authorized. The jurisdictional questions have been opened, and sworn testimony will speak to the court, not to public opinion. Three realities now define this case. First, the decision to seek federal jurisdiction created exposure far beyond the original dispute. Second, the legal claims themselves now carry far less practical weight than the discovery process they triggered. And third, once sworn discovery begins, narrative control cannot be recovered. The case is only entering its most consequential stage.